My friends, I have news about a case that some of you have been following for a while. It's about Suno and GEMA. Suno lost to GEMA in court. And you might wonder what GEMA stands for. Well, GEMA stands for the Society for Musical, Performing and Mechanical Reproduction Rights. Spelled out in German, it goes like
Gesellschaft für musikalische Aufführungs- und mechanische Vervielfältigungsrechte.
Okay, you get the idea. Well, Suno had a lawsuit with GEMA in the courts, and the bad news is that Suno has lost. This started off in 2025. They filed a lawsuit against Suno in the Munich regional courts. GEMA alleged that Suno ripped and ingested songs from its repertoire to train its AI generator without licenses or compensating rights. The proceedings began in March 2026. GEMA submitted evidence demonstrating that prompting Suno generated tracks matching the melodies, harmonies, and rhythms of major hits like Boney M's Daddy Cool, Alphaville's Forever Young, and Suno's defense in court, it argued that the court lacked jurisdiction, that its model learned musical patterns rather than storing files, and that training was covered under US fair use and EU text data mining exemptions. Well, July 31st, today, 2026, the Munich Regional Courts ruled in favor of GEMA. The court rejected Suno's fair use claims, saying that Suno memorized and reproduced protected works, and it ordered Suno to halt unauthorized reproductions, disclose revenues earned from the infringements, and pay damages. That's the summary of it all. Now, this lands the same day that the industry published the AI chart eligibility framework, the same day Michael Smith was sentenced, 3 weeks before the U.S. oral argument in UMG versus Suno. So let's break down what exactly this means. The judge sided with GEMA on virtually all points, two distinct violations. Violation number one was reproduction right, the act of storing copyrighted songs in AI model weights during training constitutes reproduction under copyright law. Suno assessed the 6 disputed compositions. US and European legal frameworks are fundamentally different, and that difference is why Suno just lost in Munich, even though the US case is still unresolved. In the US, fair use, a 4-factor balancing test that asks whether the use is transformative, whether it affects the market for the original work. Suno's entire US defense is that AI training is transformative use. That argument is before a federal court in Boston right now. In Germany and the EU, no fair use. Instead, there's a text and data mining exception under the EU Copyright Directive. That exception allows TDM for scientific research, but it includes an opt-out mechanism. Rights holders can explicitly exclude their content from TDM use. GEMA opted out. The moment GEMA opted out, even the limited EU exception no longer applied to Suno's training. This means Suno cannot run the same defense in Germany that it's running in the US. The fair use argument, the transformative use argument, the we only learned from it, we didn't copy it argument. None of those have legal purchase in German copyright law when GEMA has explicitly opted out. Google published a paper last week arguing training is fair use. That paper describes a US legal concept. It has zero relevance to the Munich ruling. The EU is a different jurisdiction with a different legal framework. And in that framework, GEMA just won comprehensively. Tobias Holzmuller, the CEO of GEMA, did not understate what happened today. This is a verdict of global significance, he said. And he is right, in a way, right? Because GEMA's full press release says the decision establishes that AI companies must pay for licenses for the systematic use of GEMA's repertoire and its commercial exploitation. Note the breadth of that language, systematic use, commercial exploitation. Well, this is not a ruling about one song. It's a ruling about the model of commercial AI music generation. The German government responded immediately. Culture representative Wolfram Weimers called it an important signal to support creators' rights in the digital music industry. He added, "We need a regulatory framework that strengthens innovation and creativity. Germany has skin in this game. The EU AI Act applies in August, and this ruling now provides a judicial foundation for the regulatory framework that follows." Well, Suno's response is 3 words of legal positioning: disagrees, evaluate, appeal. This is standard defendant language, and it means we lost, but we're not done. The appeal goes to a higher German regional court, and that process will take months. The key detail is, even while appealing, the underlying ruling stands. Suno is currently on record as having been found to have violated copyright under both German and US law by a German court. That fact does not go away during the appeal. And this court has done this before. It's not their first rodeo. It's not the first time the 42nd Civil Chamber of the Munich Regional Court has ruled against an AI company on copyright grounds. In November 2025, the same court ruled against OpenAI in a case brought by GEMA. The issue: ChatGPT was reproducing copyrighted song lyrics without obtaining the relevant licenses or paying remuneration to authors. GEMA won that case as well. Now, July 2026, the same chamber has ruled against Suno, but this ruling is specifically about AI music training and output generation. That makes it the first of its kind. The OpenAI ruling was about text reproduction. This one is about audio training and musical output. The court has now established a consistent position. AI companies cannot use GEMA-represented works without a license, either for training or for output, under German copyright law. Coda, Denmark's equivalent collecting society, has its own case pending against Suno. Today's ruling is now the precedent. They are going to cite this. The Munich ruling doesn't bind Danish courts, but it is highly persuasive, given GEMA and Coda operate under similar EU-level copyright frameworks. Every collecting society in Europe that has music being used by AI training systems is now looking at this ruling and asking, do we have what GEMA had? Can we prove training access and recognizable outputs? In most cases, the answer is yes. Now, let me walk through who is watching this ruling and what it means for each of them. Coda, Denmark's collecting society, has its own case against Suno filed, and today's ruling is now the European precedent that they are going to present in court. As I said, they operate under the same framework. What worked in Munich works as a template for Copenhagen. And SESAM, France's collecting society, representing over 2 million rights holders, has been watching GEMA's campaign very closely, and it now has a comprehensive winning blueprint, an opt-out of TDM exceptions, prove training access through YouTube, demonstrate recognizable outputs. SESAM can file the same case tomorrow. As far as the UK is concerned, we have PRS for music, and 79% of their members are worried about AI music according to their own survey. Post-Brexit, the UK had its own copyright framework. Not EU law, but the EU ruling will be cited in any UK proceeding. EU AI Act, the transparency requirements for AI training data, are coming into force in August 2026. This ruling provides the judicial foundation those regulations were designed to sit on. Companies must disclose training data. Now there's a ruling that says using that training data without a license is infringement. And there's the US angle, the most important one. The Munich court ruled that Suno violated not just German copyright, but also US copyright law. Can you imagine that? A German court interpreting and applying US law against Suno. That ruling is not binding on US courts, but it is persuasive authority. And UMG's lawyers, you already know, they're going to pull that out of the bag in the August brief. I know for many of you that support Suno, this is bad news, But moving forward, let's talk about the US case connection. The question everyone in the US music industry is asking right now: does today's Munich ruling change anything about the August oral argument? And the short answer is not directly. The longer answer, I hate to tell you, but it's significantly. Now, what it doesn't do is create binding precedent in the US court. American courts apply American law. A ruling from the Munich Regional Court is not binding on a federal judge in Massachusetts. The fair use question gets decided on its own merits under US copyright doctrine. But what this does do is, first, it gives UMG lawyers a persuasive foreign ruling that they are likely going to cite, knowing UMG's mammoth reach, because the Munich court explicitly found Suno violated US copyright law as well as German law. A court that applied US law and found infringement is not just a foreign ruling, it's an application of the same law that the US court is deciding. And secondly, it eliminates one of Suno's narrative advantages. Suno has been able to argue that no court has ruled AI training is infringement. And today, that is no longer true. Thirdly, it established international consensus momentum. One court in Europe has now said licensing is required. Coda will likely follow. Say some, probably parroting off them, is going to do the same. And as the international consensus builds, US court is looking at a world where European framework has decided this question. And the question is being decided against the AI companies. August is still the pivotal date. Today is a weight placed on one side of the scale. So, my friends, in closing, let's talk about what this actually means. In Europe, the question we can say has been answered. Suno has got an uphill battle to fight, right? GEMA wins, damages to be quantified. Suno will appeal. The appeal will take months, and during that time, the underlying ruling stands. But do you think this truly moves Suno as an organization? Of course it doesn't, because we've seen this play out time and time again. The Napster case is a good example. No matter what these courts do against Suno, using them as a public example and as a benchmark or as a scapegoat, the whack-a-mole game begins. Let the game begin, because there are hundreds of organizations that will rise up in the same way, maybe use different data, maybe position themselves differently. But there's only so much that you can do as a court. You want to force this movement underground it will go. So good luck. Today, we see history being made, but that is not to say Suno is going away. Okay? Michael Smith also been sentenced in for AI streaming fraud. It makes the future of AI music look very grim. But be aware that this is just the beginning of tens and maybe even hundreds of years to come, because as technology morphs and bends through time, there will always be the factions that fight against the technology for legal reasons, right? They brought forth legal reasons, and I don't begrudge them. But that is not going to put the movement on the run and make it go underground. In the US, the fair use question remains open. I honestly think that the courts in US will have a very different idea, especially based on what I presented earlier about how GEMA took themselves out of it. So this is a totally different ballgame in August when the federal court in Boston makes its ruling. And that ruling will either confirm or diverge from what Munich has said. And I have a strong feeling that it will not confirm what they have done today. If it does confirm, the global consensus is complete, because we know what's going to happen as far as Asia and Africa is concerned. They will probably pivot towards what has already been decided. It's easier, right? But if it diverges, you have a world where European and American courts have reached opposite conclusions about the same technology. And I truly hope that it happens, because I like a lot of diversion of thoughts and ideas. Why do we all have to parrot and conform to the same ideologies. But either way, the landscape today is fundamentally different from yesterday. The first domino has fallen. Let me know what you think. Let me know who you're for and who you're against. Speak to you in the next video.